This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why liars never prosper and an insurance policy can and will be declared void because the insured lied on the application. As my mother taught me when I was a child, liars never prosper. She was more definite than reality, although in insurance the maxim about liars must be followed. In Saul Valdez versus Nationwide Insurance Company, a September 30, 2022 decision of the United States District Court for the District of Oregon, Saul Valdez sued Nationwide, alleging a claim for breach of contract, including counts for breach of express contract terms and implied covenant of good faith and fair dealing. Nationwide, on the other hand, claimed Valdez obtained the policy by misrepresentation of material facts. Plaintiff called the defendant, seeking to add an insurance policy to one of his properties, hereinafter the property. Defendant's representative asked plaintiff a series of questions about the property to gather information and gauge eligibility. After plaintiff answered these questions, the representative of Nationwide informed the plaintiff that he would receive at some point over the next 6 days a binder and an application. Defendant Nationwide emailed plaintiff an application and insurance binder for his review and signature via DocuSign. Plaintiff signed the application on May 21, 2020, and defendant mailed plaintiff a physical copy of the policy sans the application. Around that time, and in accordance with the company's underwriting guidelines, for newly insured properties, defendant opened an independent investigation to verify the information plaintiff had provided about the property. A third-party independent investigator visited the property and provided a report to the defendant. Before a report was obtained, however, a fire occurred at the property, resulting in a total loss. When plaintiff did not receive any adjustments or payments from Nationwide, he sued. Roughly a month and a half later, on August 25, 2020, defendant Nationwide issued a letter to the plaintiff declaring that the insurance policy for the property was rescinded back to its inception date. The letter explained that plaintiff at the time of the application misrepresented, concealed, or omitted multiple points of important, that is, material information, and that if truthful information had been provided, Nationwide would not have accepted the application for multiple underwriting reasons. Plaintiff's motion seeks summary judgment on all 5 of defendant's affirmative defenses: policy rescission, breach of the policy condition, real party and interest, lack of insurable interest, and failure to state a claim. In its response to plaintiff's motion, the defendant Nationwide stipulated to the dismissal of its 4th and 5th affirmative defenses and therefore conceded summary judgment on those affirmative defenses, but continued with its claim for rescission. The first element that an insurer must demonstrate to void a fire insurance policy is that the insured either willfully concealed, misrepresented, or falsely swore any fact or circumstance concerning the insurance. Nationwide submitted distinct examples where plaintiff's representations on his application differed from the true state of the property. 1. Plaintiff presented on his application that the property was not currently undergoing extensive remodeling or additions. The realtor representing the plaintiff provided in a deposition that the property was being remodeled for sure. Plaintiff conceded during his deposition that the electrical work wasn't complete. There was no finished flooring, no hung sheetrock, no installed countertops or appliances, no bathroom fixtures or toilets, and no insulation or wood paneling in the upstairs sections. 2. In similar vein, plaintiff also represented that the property was suitable for occupancy, specifically as a one-family home, but in his deposition, plaintiff's architect opined that he did not believe an inspector would give a certificate of occupancy for a building in the condition it was at the time. 3rd, plaintiff claimed on his application that there was no business on the premises of the property, but by his own admission, plaintiff was running his business on the premises of the property, and his representations that there was no business on the premises was false. 4. Plaintiff denoted on his application the property was not subject or liable to any additional insured parties or interests. However, the deed on the property was in the name of plaintiff's property management company, Renaissance Properties, LLC, not the plaintiff. 5. Plaintiff claimed that there was no prior insurance on the property. The property was insured, however, for at least the first year after the sale and before the application for insurance. And 6. Finally, plaintiff indicated on his application that the condition of the dwelling was excellent. Yet both the third-party inspector and plaintiff's architect observed that the windows of the property were boarded up in late May 2020, close in to time when plaintiff submitted his application to the Nationwide. Both individuals also confirmed the presence of graffiti on the property, and the third-party inspector observed that the property contained an attractive nuisance of inoperable vehicles, junk appliances, farm equipment, and excessive trash and debris. Insurance fraud or false swearing in Oregon is purely a civil dispute, and accordingly the measure of proof is by a preponderance of the evidence. In civil cases, the word willful amounts to nothing more than this, quote, that the person knows what he is doing, intends to do what he is doing, and is a free agent. On balance, defendant's evidence, which demonstrated blatant misrepresentations surrounding the conditions and status of the property, along with plaintiff's silence regarding his state of mind when reviewing and signing the application, overwhelmingly tipped the scales in favor of a finding that plaintiff made willful misrepresentations when completing his application. Now, Oregon requires that the application be attached to the policy, and the court concluded that under Oregon statutes, the fact that he signed the application, which was attached to a binder, which under Oregon law is a policy, was sufficient to meet that requirement. And it was obvious to the court that the representations made by the plaintiff were material to the decision of the insurer to insure or not insure the risk of loss of his property. Lastly, to void a fire insurance policy, an insurer must demonstrate that it relied upon the applicant's material misrepresentations. Nationwide proffered evidence sufficient to establish a prima facie case of reliance. It established the 4 elements required under the statute to effectuate successful avoidance of plaintiff's fire insurance policy, and because Nationwide successfully voided the policy, plaintiff's claim for breach of the express terms of that contract falls. Defendant's motion for summary judgment is therefore appropriate for plaintiff's claim alleging an express breach of contract, since there was no nationwide contract because of his material misrepresentation. Having found that the policy was successfully voided as to any party, There was no need for the court to reach any of defendant's other arguments that plaintiff was not the proper party in interest. Nationwide's motion for summary judgment was therefore granted in full. In my opinion, insurance has always been a business of the utmost good faith. An applicant for insurance who lies on an application for insurance about facts that are material to the decision of the insurer to either insure or refuse to insure a person against the risk of loss by fire must be voided. In this case, the lies on the application were obvious and egregious. Valdez lied to get the insurance and was faced with the effect of the lie, which showed a serious effort of unmitigated gall by filing suit against Nationwide, knowing that he had lied blatantly to obtain the policy. The court found 6 clear misrepresentations of material fact when one would have been sufficient. Valdez should have been sanctioned for bringing a spurious and frivolous lawsuit. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the link zelma.com/blog. It is available also as a video on YouTube and rumble.com and on my Substack publications and on rumble.com. If you found the video and the blog posting to be of interest or useful to you, please tell your colleagues and suggest that they also subscribe to the blog and to my locals and Substack publications. Thank you for your attention.